Good evening, Jural Assembly. We are now to Jural Assembly training number 7. And so tonight what I want to do is kind of make sure that I get things recorded. I want to go over a little bit of a review, and then I want to just kind of talk about how this court process is actually supposed to work in common law, and what we're going to attempt. Lawfully attempt in some different areas, and just keep everybody up to speed, and just kind of see where everybody else kind of stands on that. So anyway, first thing that we've learned is that there is a difference between a judge and a magistrate. In the de facto courts, they have judges, and those judges make rulings, and they decide things, and they give orders. They pretty much anything they say or do goes, and that's in the de facto court. In the common law court, when you have an official in a judge position, it's a magistrate or justice. That magistrate can be, in common law, it can be the coroner, it can be the notary, it can even be, there's someone else that can be, and I can't remember right offhand, but it can be those people as well that can operate in that magistrate position. But that magistrate position of justice in the common law makes no decisions. They are just there as an administrator to administrate things and give suggestions to show law. But the tribunal of the court in the common law is our jury, either our 12-man panel jury or our 25-man panel jury, or the sovereign and his suit is also the tribunal. When I say the tribunal of the court, what do I mean? That is the ones who make the decisions. So they're called the tribunal. So we have our petit jury, 12-man jury, grand jury, and then we also have, if the king, for instance, we've taught on this before, if the king is by himself and doesn't have his court with him, because remember, we are sovereigns, so we are kings. And so if the king doesn't have his court with him, which is his lawful jury, then what he has and can be a tribunal is the sovereign and his suit. So it would be the sovereign and his court of record. And so your court of record is the suit in this case. So the tribunal in the de facto is the judge. The judge makes all the decisions. They're the ones that decide everything. And so you have one man or woman sitting on that bench deciding your life. And so that's de facto. Now, we are owed through the Constitution common law, the law of the land. So when we come into common law and the sovereign comes in and claims his case, his or her case, and brings their suit, which is the court of record, to who? The tribunal. In our court is going to be the jury. We've learned that the court of record, that sovereign right, is going to have communication to the jury. We've learned that. So that court of record is going to have communication to the jury. And the jury is to take that and look at it and deduce things for themselves, and then come back and make a decision. So that's where they come back with a verdict. Now, when a jury deliberates in de facto, it's not a trial by jury. It's actually called a jury trial. In de facto, they're called jury trials because there's no sovereigns on the panel. There's no state citizens there. And so it's called a jury trial. They're also in the de facto not allowed to use jury nullification, where they can nullify laws. They actually many times do the bidding of the prosecuting attorney and the judges. That's just a fact. But the jury in a de facto is called a jury trial. The jury in common law is called a trial by jury. Now, our verdicts in de facto, they'll come out and they just say guilty or not guilty. That's kind of like elementary math, which is 1 + 1 = 2. In the de facto, when the jury gives their guilty or not guilty, then the judge will usually write up a report of what he or she feels to write about that case. It's the clerk's notes and the judge's notes, and so they write their reviews. We see that many times in the Supreme Court, where when they do their rulings, because see, they rule without a jury, but they'll write a whole report. So in our courts, when we get the verdicts in de facto, the judge does that stuff. And they don't really go into a whole lot of detail in that. But the verdicts in common law are much different, because in common law, when the sovereign sends his suit to the jury, then the jury looks over the suit, and when the jury sends the verdict out, okay, the jury will send the verdict out. Now remember, the jury is called a slice of the population, I guess you'd say. So American common law has decided that 12 people, actually 13 or 14, because you've got your 2 alternates, are what is needed for a petit jury, and it is a correct sampling of the population to be able to hear the population's word on the matter. So, so when the de facto common law verdicts come out, they come out in algebra form. And what I mean by that is, in de facto, they do 1 + 1 = 2. They're guilty. In de facto, in common law, when you come back, it's more like show your work. X = 7, but you had to find that with the formula and show your work. And so, for instance, a jury, you have to show how you got there. So, for instance, if you're saying that the defendants in the case are guilty, then you as the jury have to take that mindset and say, okay, how are they guilty? What do we see as evidence? What is shown as evidence in that? Oh, are we doing the reimbursement of damages or punitive damages? Then you would show your work on that as well. So each part of the case that you're working on, when you're given verdicts and different pieces of verdicts, you have to show your work. Now, let me tell you the reason why you show your work. This is interesting. It's really simple. The reason you show your work and make it would be a verdict, but it's still done like a court of record. And the reason it's done like a court of record is because now this verdict is going to be published for all the world to see. And so now you as the jury are telling the public, you know, who you are a slice of that population, you're telling them how you got to that and how you came to that, so that they too can correctly see how you got there and be in agreement with you. Because if you're all unanimous when you make these cases, there should be no shadow of a doubt that they're guilty, which is why our common law courts cannot be overturned. Our verdicts cannot be overturned by the de facto. When we sit down and come to an agreement on things, it's set in stone and can't be appealed or reversed or overturned. Not unless there was gross malfeasance on the part of the officials of the common law court. If there can be proved that the officials had malfeasance in the actual court and it's the officials, then they would consider a retrial in that case. But usually no. All right, so now, how are the common law courts supposed to work? Okay, so here's what we've done. Just give a review of what we've done. we have set up our courts. We held our, we gave notice we were holding an election. We gave the candidates time to prepare. We held an election. We gave notice for 60 days. Before that, we had the election, put our people in place, got our grand jury in place, sent notice out for ex parte Milligan to everybody to let them know we were here, and then we started our courts. And our people began sending out notices, because in common law you have to give due process. So we sent out challenge jurisdiction notice. We did more than that. We did 3 notices, and then we did 3 invoices, and then we liened them. And I really don't think, even in the law stuff that I'm looking at, we don't have to do the 3 invoices or the lien, because according to ex parte Milligan, when the common law court for our state, since our state was one of the rebel states, according to ex parte Milligan, when it states in that law that once the common law courts are back up and running, then whoever is challenging jurisdiction, or whoever should be in land and soil jurisdiction, they should go to that court. And so our courts are up, and that includes us. And it tells us in there that when we get verdicts out of our courts, that those go to, because of ex parte Milligan, the verdicts that come out of our court are then sent to the Chief Supreme Court Justice. For us, that's John Kemp. And our verdict is sent there for him to read, and then he passes that down to the lower court for enforcement. And our justice writes 2 writs that go to that. One is for a writ of, it's when it starts with the E, when you do something, X something. Anyway, I can't think of it right this second, but it tells them to do something. And so you're asking them to pass the verdict down to the lower courts. And basically we ask for the power of that court and the authority of that court to pass it down in the de facto. And then once we do that, we send also a statement of cause, which is also a writ that says, you have 10 days to send it down. If you choose not to send it down, please contact our court to tell us why you're not going to pass the judgment. That gives us access back, because they have a duty as well. The Chief Justice has a duty to enforce the law, and enforce right verdicts. And so if they don't respond to you and they don't give the verdict, then that gives us the opportunity to come back and with a letter and a notice that says, hey, it's your duty to act on this, and we ask them politely to act in that duty. Or to contact us so we can talk about it. And then you do the same notice process. Hopefully it won't come to that, but that's where we go with the Chief Supreme Court Justice. Now, because we know we do the court of record, and we know that the 3 types of sovereign, our state has quite a few things going on here. We have a case that's being done out of state, and so in that case, it's going to be the tribunal is going to be the sovereign and his suit. It's going to be you go into that court and you challenge jurisdiction, and once you challenge jurisdiction, you give notice, demand that it be turned into a common law court, a court of record, and then at that moment, that court, that justice that's on that court bench cannot make any other decisions. And so then you literally just, through writing writs and motions on your own, void judgments and take over the case. So we have someone that's going to be attempting that. He is working on attempting that. We also have different ones where cases are already closed. Now, it looks to me, based on what I'm learning, that once a case is already closed, it doesn't actually have to go through the grand jury. Those cases go straight through a claim in our court, and then it just gets tried by the jury. And once it's tried by the jury, then it goes through the Supreme Court for judgment. And then that's how those go. Those should be actually pretty quick. You just rule on those cases as a common law court, and then it overturns the lower court's verdict. Those should be simple. Now, the cases where we have people who are entangled in things that are in our state, those are ones that we're trying to pull out of their court and into our court, and we have not been successful with the challenge of jurisdiction. In fact, no one really answers. We did have one answer. One judge actually did answer, came back with a good question on an answer, and then the defendants in that case ended up coming back and shooting that down. But it was good that they asked something. So those cases of the ones where we have court cases, we have one that's fixing to go to trial, and we're going to attempt to challenge jurisdiction and then immediately file a claim and then try to pull it into our court from their court, and not given as much time of notice since they're not responding to it anyway, and just see what they do. The only thing is look, guys, we're just testing the waters on these. Everything we're doing is lawful, but it doesn't matter when we get in their courtrooms anyway. They just railroad all of us anyhow. So, it's going to be interesting to see how we do with the suit, the sovereign in his suit, for the case that we have that's out of state, where they're going to have to absolutely turn the court into a common law court, and do things in writing. And then it's interesting to see on these cases that we're fixing to pull in and see if we can skip a whole bunch of notices and a whole bunch of that's contract law. Actually, when you're given all of those notices and then the invoices and then the liens, you actually turn that into contract law, which is we shouldn't have to do that, because it turns it into a contract when common law doesn't run on contracts. So anyway, that's just the points that I have on that. Those are the things that we're looking at as we move forward, and we're learning. We've got people now that are going to learn how to do a court of record and working on that, and our jury now is learning how to show their work and show how they got there, and then they'll learn how to put together a verdict and how that works, and how to put it together to where you can show the rest of mankind why you came to those decisions, and how you got there, so that it's clear to all that you've made the right decision. And so, anyway, that's all I really wanted to talk about tonight. I know that that's not very much. I know that that's a little shorter, but I'm going to open it up for questions in case people have questions. We may dig this a little further if y'all want to push in and give information or questions, anything you want to do. But I'm just going to kind of make it a little shorter. We've been busy, real busy. So I'm going to open it up for you guys. Should be able to unmute yourselves if needed and see if anybody has any comments, any suggestions, any questions, any thoughts about what we're trying to do and how we're moving, and what direction we're moving in these cases, and just see your thoughts. The floor is open.
This is Robin.
Yes.
Based on what you just said about contract law, do I need to send any more notices out on my end for the police officers? You
need to at least have done your first notice and your second notice, which is your opportunity to cure, because you do want to show that you're given due process. And then the third letter of default. But don't do, I'm personally, I'm recommending, based on what I see, to not do the invoices or the liens at all. So where are you at on that, Robin? Does that answer the question? I don't know where you're at on the police officers.
One declined my second notice, and I don't know if the other one accepted it or not. But I'm sure that there's going to be declines for second and third, so I'm going to have to work on serving.
So here's what I would do. I would give them, you know what? Okay, so guys, here's a suggestion. So y'all just help me out here, because we're walking in lawfulness, but we want to do what's right. But at the same time, we're spending a whole stinking load of money sending these things. Well, I mean, yes, she has 2 more to send, but they already are ducking. They should be answering these things, these questions, and they're not. And so I say don't send the last 2 and come and bring the claim to our court. And once you bring our claim to our court, they'll get served with they'll have to get served to come into our court. So we'll just serve them then, you know. They obviously know because you have the proof they rejected it. You see what I'm saying? You have the proof they rejected it, so they've gotten the first notice. At that point, you're right to assume that they don't want to hear from you, and they're in default. Thoughts on that, guys? I mean, Robin, does that sound good to you? I mean, just go ahead and file your claim here, and then we'll serve them and post it. We'll post whatever we need to post in that one. If we're having to serve the documents, we might as well serve them everything all at once, is my thought. You know?
I agree. I think that's a great plan, because I think it's like you said, I'm spending a boatload of money and not getting the result of a response or even acceptance, receipt. So, if that's the case, I'm ready to go. I just had questions because in my particular case, how do I list defendants? I've already properly served everything to the judge, but the police officers are giving me a hard time. So when I was listing the defendants, it was the actions of the police officers that prompted all of this. So when I was listing my case out, a lot of it was the actions of police officers and, of course, the evidence. So I can gather all my evidence and get everything to you and modify the names of the defendants so that we can move my case to trial.
Yeah. Hey, Robin. So are you going to put your defendants as the officers, the police officers, the Tuggle and the other one, and then are you going to list Lance Wright as a defendant also?
Yes, ma'am. Yes, ma'am. Because he did not respond to my request to dismiss the case, and he has suspended my driver's license, and I have warrants. So
yeah, so he did that. Okay, all right.
Mm-hmm. Right.
So are you going? So Kimberly, what you're talking about, Ashley's going to do that. She's going to. What do you do it? Not the complaint. You go in to turn it into a common law court. What did you say that's called?
So you turn the court into a court of record is how it's going to be pronounced in their court. And it does it in a simple, like, 2-sentence. Right. The moment you read that 2 sentences turns the court that way. And look, the judges sometimes will think they will act, and then you can void their judgments, and they'll be sitting there going, what the heck's going on? I thought I ran this court. And it's actually quite funny. I'm curious to see how it works for us.
Oh, I am too. But what is it that you have to file? It's like a
counterclaim. It's a counterclaim.
So she's going to file the counterclaim. But now, so in that case, so hers is just going to be concurrently happening in our courts, common law courts, while this de facto in Cleveland County is just sitting there because she hasn't come. That's what I guess what Anna was talking about. They can run at the same time concurrently.
Yes, they can run concurrently.
Okay.
And that's what our first case is doing, is running concurrently. And so we can run them concurrently.
Okay. All right. Well, today I was listening to that podcast, and Anna was saying, she was talking about when the states are up and going, the courts are going, and you have the indictment, and then it's given to the DA. So I have a question, and I don't know if this is appropriate tonight or not, with what's already happened with the grand jury and that indictment. It was sent to the U.S. attorney, who's the top DA, I guess you'd say, in the state.
That's right. That's David Fouts.
Right. But was it also sent to the Garland County? It's not a DA. It's a prosecuting attorney who is also a defendant. Was it sent to the prosecuting attorney in the official capacity?
No, it was not, because it was the duty of, because we're sending it from common law to de facto, when we send stuff like that for indictments or whatever, it should have, so the way it should have rolled out, common law and legal meshing together, is what it should have done. And see, he's in dereliction of his duty as well. We just haven't addressed that yet. But what should have happened was he should have sent that down to the lower courts and delivered that to them.
Right.
And he should have made sure that they contacted us and that they showed up for court. That was his duty.
Okay. Yeah. Yeah.
So I didn't send it to anybody on the lower courts, because remember, we're a general jurisdiction, highest court of Arkansas. So when we deal with them, we go to their highest, like the Supreme Court Chief Justice, and like the district attorney of Arkansas for that district, whoever that one is.
Yeah.
And then it filters down. They're the ones that enforce the law. They're the ones that enforce that to their people. Now, we are able to do writs. Like our jury wrote a writ of cease and desist.
Yeah.
And that went directly to them because, see, at this point, according to the way common law works, according to the way that it's really supposed to work, it's really supposed to work without the ex parte Milligan, and had we never lost our whole common law court system, how it's supposed to work is our justice and our officials are supposed to talk to their officials, and jurisdiction is decided among them, and then they just transfer it to whichever court it's supposed to be at. It's really a simple process.
Right.
But these guys are not in the, they don't recognize us yet. But it should be a simple switch.
Right. Well, they're making money. We're not in this to make money. We're in this to do it right.
Right, and so we're going to be exposing a kaboobaboo of corruption as we establish ourselves.
So David when you were talking about the writ, he was sitting here. He said, "Were you meaning to say the writ of execution?"
That's it. Yes, I was like, it starts with the E. I can't get it out. Yes, it's the writs of execution. So there's a few different writs of execution, and basically what you're doing is you're asking for the power and authority of that higher de facto court to act and use their power and authority to execute the judgment. Okay. And you do it nicely. You know what I mean? You ask them nicely because it's their duty, and they should just they're supposed to roll it down.
Even though we want to tell them what we think, we're not going to do that.
No, we're not. We're going to continue to stay in honor. And if we have to go above and do dereliction duty on those guys, then we will. And then that's where you get Tim Griffin and Sarah Sanders involved. So, I mean, we have a game plan per se, depending on how this thing rolls out, because we don't know how it's going to roll out. Or I don't know how any of these are going to roll out. But we know that we're right in what we're doing. But here's the thing. So strategy, public opinion, So, for instance, on these cases, public opinion matters. And when we build our verdicts as a tribunal jury, or when you build your verdict, if you are the sovereign with your court of record suit, when it comes down to judgment, guess what? You are the one that is the tribunal. You're also going to give the judgment. But if you show your work giving your judgment as a tribunal and not as a plaintiff or a claimant per se, you're actually using the tribunal hat and wearing it, then you should be able to, I don't want to use the word sell, but it is. You should be able to sell the world with your, quote, verdict court of record with everything in there that makes it beyond a shadow of a doubt that you were wrong. You see what I'm saying? Because if you're the plaintiff and you're saying that all these guys are wrong, when that verdict comes in, anybody should be able to read that and go, oh yeah, these guys are way off. That's exactly right. And so it becomes a public record, and it'll be posted on our website for all the public to see. But going public is good, because when you have that and then the public finds out about it, you can tell them to go read it and let the public decide. See what I'm saying? Because everything that you need is in that, and just then you can let the public also stand with you. So if these guys don't cave when we start showing our cases to the public and getting the word out there and people actually sit down and read it, then we begin to build numbers on our side. And when we, the people, stand up and the numbers begin to build, then there's no stopping it. And we have many de facto people that are, also standing up for the Constitution, and we've got to stand with them too, So, anybody else want to add to that or have anything they want to say? I kind of went off on tangent for a second.
Yes, you just brought something else I was thinking about. This is Robin again. Today in the live stream, it was mentioned that we go by the Declaration of Independence, not by the Constitution.
That's correct.
Okay. I just wanted to make sure that I understood that correctly, because we're talking about the Constitution right now. So
let me explain it. I'll just take a minute and explain it, okay? So how that works is, so we the people, before we became a country, right? So we have to go back. Before we became a country, they were fighting the Brits off, and they were having the same things that we're having here, the courts. A lot of it was the courts and the fees and taxes and all that stuff. Anyway, so it started there, and that's where we got our Declaration of Independence. It was we the people declaring that we're not standing under this mess. We're sovereigns. This is who we are, and we're not standing for no tyranny, no nothing. And so they laid out their law right there. The sovereigns did. And so that's when we took our independence, right there. So when you come into the constitutions, remember, the constitutions are contracts. They're contracts between our federation government. So see, look guys, our federation government, Anna, and me and Will are under that as well, and not anybody that's an official, that's for the United States of America. Then you have the second contract, which is the contract of the United States of America, and that is with United States of America, Inc. And then the third contract, which is Britain. Then the third contract is the third United States Constitution, which is the Constitution of the United States, which is the Vatican. Okay? So those are constitutions that we, the people, wrote to our three forms of government, okay? We wrote those for them to abide by, and they owe us guarantees out of that. So, for instance, let me just explain to you. Anna and the Federation owe us guarantees out of the Constitution, the first Constitution that we have. And that is, they give us coinage. You see what I'm saying? They coin our money. And so that's what they're doing, is coining our money for us. But so there's guarantees that they have, that all of those forms of government owe us the people, which means they can do a lot of their own things, but they cannot trample our rights. They cannot trample our constitutional rights. But they're guarantees. So we actually don't fall under those three contracts. We're outside of those contracts. We're owed guarantees from those contracts, but those contracts are for those governments from we the people of the 19 delegated responsibilities that we gave to them. So we actually, all we the people, we fall under the agreement that we all made when we gained our freedom with the Declaration of Independence. So that's actually, yes, that is correct. Anybody else have anything?
This was good tonight.
This was good. This was good. I hope everybody is comfortable with, we've got a lot going on behind the scenes of people's cases coming up. There's a lot of people working on stuff in the background. And so, I mean, I know some of you are working on verdicts and stuff, but there's a lot more under the surface that we have going on. And so I just kind of wanted to give you guys an update on that and just kind of let you know how we're flowing with it in common law, and just remind you guys, look, at this moment, there is not another court that has gotten as far as we have gotten, to my knowledge. If they have, it's not public. So we know we've done everything lawful. We know that everything that we're moving forward in doing is lawful. We just have to see how we can break that. We got to break through the fog of the laws. No one's seen a common law court in a long time, so I mean, we've got to literally teach people and bring this thing out, and they're just going to have to learn. So I don't know how long that's going to take, but we're going to do everything we can.
I have a question.
Yeah.
Let's say going down, because you're right, they are totally ignoring us at this point, and so we are just playing a game, and they're just waving us off. What if? I know we're not there, but if the Chief Justice, Kemp, if he were to do the same thing, would we then take it up? Would we take it ever as far as the Supreme Court in Washington, D.C.?
I don't see. Well, okay, so here's the thing. And that's where I've got to find out, because federal cases are not supposed to mingle in common law with state cases. So I don't know. I would have to research that before I would say yes. But what I do know we can do is we can take it to the highest authorities in Arkansas state, the governor, that we can take it through legislature. We can send it everywhere in Arkansas. I do not know if we are able to move it through the Supreme Court, because here's the reason. The way it was set up, we are the highest court in the land of Arkansas, so our decision should stand over theirs. And because our state is its own country and its own nation, we don't have to go ask the government for us. You see what I'm saying? We're actually in a pickle if they don't actually bend, because unless Anna or somebody clears a way, we would have to take someone from the Federation with us. Does that make sense? Because then we would be out of our jurisdiction.
Yeah, if you send it to the Chief Justice of the Arkansas Supreme Court and he doesn't do something about it, then, and of course these are questions that we don't know the answers to. I guess there's really no reason to go there until we find ourselves in that position. But even in the de facto, you take it from the district up to the appellate court, up to the Arkansas Supreme, up to the federal appellate. I mean, then it moves on up that list. So I don't know if Kemp, if he fails to do what he should do, then if we would take him to the appellate level of the federal, for the appellate level of the federal, using Ex parte Milligan to come back and tell Kemp, remand it back for him to do his job. I don't know. Just a question.
I don't know, but I'm thinking if we, and this is where, I mean, see, and Anna and them haven't got this far, but this would be a question for Brent Winters, and I don't know how to get a hold. That question would be for somebody up above, because I'm thinking in order to be in the federal jurisdiction court-wise, we are now out of our jurisdiction as a state. So we actually would have to take someone from the Federation with us to be able to operate in that realm. Does that make sense?
Yeah, that would be the international.
We used our U.S. and see who that would be. Now, let me just explain who that is supposed to be. And see, we can't, until all of our courts in our states, for all 50 states, are set up, they cannot give us the protection of the U.S. Marshals. The U.S. Marshals are supposed to be the ones that make sure everything gets enforced so we don't have to go federal. Does that make sense?
Right, yeah. Brent Winters actually is starting a class on Friday, which if Adam LaSalle is on the call, it would be something he would be interested in. So, and that's on Friday. That's another matter.
Well, and I'm just going to put it on the record, too, because you and I talked, and he needs to contact the Peacekeeping Training Force. I think it's PKTF.org, right? Or is it .com?
No, it's .org.
Okay, PTKF, Peacekeepers Training Force, PKTF.org, and get hooked in with them. Our state marshal of arms is supposed to do that. So I'll send him a text in case he hears this before I send it to him.
Well, I'll look that up and I'll send it to you because you've got his email that you could send it to him.
Absolutely.
Okay.
All right. Anybody got anything else? Anything to add? Any thoughts, suggestions?
Well, I wanted to add to what Nina was just asking. If this goes public and we have any pushback whatsoever, I think the public, if they look into the case, we will have favorable public opinion to support us. So I look forward to the fact that I think that we will have favorable public opinion on what we've done thus far and what we will do throughout this one case. So I think they would get pushback if they didn't do the right thing, because if the public is informed and therefore I think the public will see things the same way as we did.
Absolutely.
Yeah, I agree too, because the other night, and this may have been a week ago, there was something on the 6 o'clock news with David Couch. I think he's an attorney, but he is kind of rogue, and he takes these things, and seems like, I don't know that he was talking about common law, but what he was saying was like, you know what? I like what he's saying. It's right, because he was like, what you're doing is wrong. So you're right, Robin. I mean, people like him who have made a name for himself as being on the out. I mean, he's the one that's going to always come in with something different. It's people like him that may pick this up and take it also and take it further on down the road. We could only hope that.
Yeah, not only that, these guys are in the middle of elections. We're coming right on their elections. They've got signs everywhere, and they've got a lawsuit on them right now. So as soon as this goes public and when the verdict goes out, and this goes public when the verdict goes out, it may ruin their. In my mind, I hope it ruins their election. We have people. I'm just telling you, we have people right now that want to interview us and make it public. I've told them not till after the verdict comes out.
Well, I find that, I mentioned this a couple weeks ago, when the trial started for this particular one trial that's going on right now. Timing. Look at the timing. It's all lining up, and I don't think that that's a coincidence.
No, that's creator.
Yeah. No coincidence. Wow.
I think we're going to eventually have to do something like the other people did to our governor, too, because she snubbed us. She turned us down, and we're her employers. She should not be able to tell us, no, I won't speak with you. So I think at some point we're going to have to address that, too.
I agree.
Can y'all all see us on the news, standing behind the news person saying, here's what they're doing, and this is what I can just see us. Oh, my goodness, y'all.
Absolutely. It's going to bring an uproar, because it'll bring an uproar in DeSoto County, and there's some people here in DeSoto County that already know about this case and have known about it for a long time that are ready for it to make an uproar, because they already know how botched it is.
Where's DeSoto County?
Not DeSoto. I'm sorry. Garland. I used to live in DeSoto County for like 10 years. I'm sorry. Sometimes I revert back to, Garland County. That was Mississippi. That was Mississippi.
Garland County already had that negative report on him. It just kind of stopped and went away. But it's about time for that to get resurrected again.
Right, and that was Michelle Lawrence. That was the prosecuting attorney who was getting railed because of her silence. They were silencing the defendant, not silencing them out.
Well, look, it's a little bit different, but she's still right at the heart of it.
Yep. Yep, it's going to get interesting, so we're good.
When Ashley goes in there on the 15th to do this counterclaim, some of y'all need to be there too. Now, Robin, you can't come. You don't want to go back up in that area. She's going to be in Quitman, not in Heber, but it's still going to be in Craighead or Cleveland.
So wait a minute.
Cleveland, uh-huh.
Yeah, and what time?
No. I want to be there. No, I don't think you want to go.
What time is court?
I'm not sure.
Find out and we'll send it out in a text to everybody.
All right. Oh, Ashley, she couldn't come tonight. She called. She said, I can't. I'm on my way in. But, so anyway. She's nervous, but it's got to be done.
Yeah, it's got to be done. Well, on her case, am I correct in saying on her case, what we're trying to do is y'all are just trying to flip the claim into a counterclaim and then just immediately bring it into our court. Is that correct?
Yeah, bring it directly into the common law court, yes.
And then just put it when you do the writ, or when we do the statement that does that, and you take control of that court, then you can also put in there too, in your thing, because you are the tribunal, you can say that the verdict will be brought back into this court of record for execution. You know what I'm saying? And
right.
let's just see what happens.
Yeah. Yeah, I think she's planning to give you a call tomorrow. That's okay.
Yeah, that would be great.
Yep.
All right. Anybody else got anything else they want to say or add or suggest or anything before we close this out tonight? If not, everything was great, and I thank you, and I am so excited. Thank you guys, our officials, our jury, our tribunal. You guys are amazing, and